Great day, everyone. This is Ags Legal Sherpa. I'm Lex. I'm here to talk about foreclosures today for you. Listen, if you're dealing with foreclosure or any type of legal issues, I have something for you. I want to help you get the answers, get the things that you need to fight your battles, all right? 99% of America knows anything about law and how to handle itself in court. We are here to educate you. We are here to help you understand, all right? Along with AI and all types of research and all types of things, we are able to give you access to the knowledge and the things that you need to fight your battles. So let's dive into this foreclosure, what they call the Foreclosure Defense Handbook, and give you some key insights to fighting foreclosure. And in my link that's in the bio, you can get access where I can answer your questions and we can talk about where you at and figure out a way to get you to a better spot, especially people that can't afford attorneys, people that can't afford to fight. I have a way for you to be able to battle and do the things and get access to the things that you need. All right. And remember, this is here to help you. This is here to help you. This is educational purposes only. Let's dive into this. All right. Now, part of the foreclosure process or part of a loan process is called securitization. All right. That's what the banks do. All right. When a loan is securitized, the promissory note is converted into a stock, and the real parties and interests become the individual shareholders of what they call a real estate mortgage investment conduit trust. This process effectively transfers ownership of the loan away from the originating bank, which no longer owns the note and therefore lacks standing to foreclose. Now, moreover, the REMIC trust itself also lacks standing to foreclose, as it only holds the securitized loan known as carry juice. Now, while the individual shareholders are the true parties in interest, let's look at some key points. Point one, the bank that originated the loan no longer owns the promissory note after securitization. Now, point two, the REMIC trust only holds the securitized loans, not the actual promissory note. You see the separation? Now, key three, the individual shareholders of the REMIC trust are the real parties in interest. Now, they have to perfect the chain of title. It has to be established. To establish standing to foreclose, the bank must demonstrate a perfected chain of title for both the deed of trust or mortgage and the promissory note. This means providing clear and unbroken evidence and transfers of these instruments from the originator to the current holder. Blank assignments or incomplete documentations are not acceptable proof of perfection of title and can be challenged in court. Now, one, the originator, the bank or lender that initially issues the loan. That's when you sit down and sign from whoever you did business with. What happens is then they basically transfer. So when they transfer, or what they call assignment or assignment of the deed, the promissory note must be properly documented. Okay, so the deed, the mortgage, everything must be documented together. The bank or entity claiming ownership must demonstrate a perfect chain of title from the originator to the current holder. So from the start, from 1 to 3, everything's supposed to stay together, and we know that's not happening. All right, they have this system called mirrors. Mirrors are invalid assignments. The mortgage electronic registration system is a controversial system used by many banks to track mortgage assignments. However, mirrors do not have the legal authority to assign the deed of trust or mortgage or appoint a trustee, as it is not a real party of interest. Any assignment or appointments made by mirrors are therefore invalid and can be challenged in court. That's fraud. Mirrors is a private electronic registry system used by banks to track mortgage assignments. Mirrors does not have the legal authority to assign deeds of trust, mortgages, or appoint trustees. Any assignments or appointments made by mirrors are invalid, as it is not a real party in interest. Now, we all know about the whole robo-signers. We saw that in 2008. That stuff still goes on. I don't have documented proof, but you hear the horror stories, and I see documents that's been forged and things like that. So we know this stuff still goes on. So in an effort to create the illusion of a proper chain of title, banks have been known to employ robo-signers who mechanically sign documents without verifying the accuracy, even fabricating documents entirely. These fraudulent practices undermine the validity of the bank's evidence and cannot be used to establish standing to foreclose. So, one, forged documents. Banks have been caught fabricating documents to create a false chain of title. Robo-signers, employees who sign documents without verifying their accuracy, often use forged or unauthorized signatures. Fraudulent documents due to these practices cannot be used as evidence in court. So we have to learn, how do we strike that evidence in court? How do we keep it out of court? These are the things in education that ASKLEGALSHERPA is trying to provide to you. Okay. Fair debt collection practices act. After 60 days of delinquency, this is very important, the bank becomes a debt collector and is subject to the Fair Debt Collection Act. So that means, what does that mean? Verification, validation. Let's make them validated. The law requires the debt collector to validate the debt upon request, which often puts the bank in a difficult position. Why? Because they have separated the promissory note and the mortgage. If the bank cannot provide proper documentation to validate the debt, it may lack standing to pursue foreclosure action. Understand, they might be doing this, but you have to be able to do due process through the courts to make and show this. But you also got to understand that there are laws and rules to follow in court and procedures. And that's where we're here to educate so that you can do it right. Day 1, mortgage payment is due. Day 60, the bank becomes a debt collector and now falls under the Fair Debt Collection Practices Act, which is another conversation we will get into in future videos. Day 61, a homeowner can request debt validation, which the bank must provide. Debt validation letter. Now, sending a debt validation letter, which this system that I'm going to show you can help you with. If you get a question or you send me a message, I will show you this. All right. Send a debt validation to the bank can be a powerful tool for homeowners facing foreclosure. This letter forces the bank to provide proof of their standing and validity of the debt, in which they are often unable to do due to the securitization process and lack of proper documentation. If the bank cannot validate the debt, it may lack standing to pursue foreclosure actions. The debt validation letter formally requests the bank to provide evidence validating the debt and their standing to collect it. Bank's burden of proof. The bank must provide clear and convincing documentation to validate the debt and their authority to collect it. If the bank cannot validate the debt, it may lack standing to foreclose or subject to penalties under the Fair Debt Collections Act. Bankruptcy. Bankruptcy is always an option. It puts a stay. It stops everything. It prevents the bank from going forward with a foreclosure. It allows you to figure out what you want to do as far as your money, getting it caught up, things. But again, this is all part of this process that you can leverage to slow a foreclosure, stop a foreclosure. It's all part of the process. This can provide homeowners with a viable time and leverage in their defense against foreclosure. All right. You file bankruptcy. There's an automatic stay. The bank must provide evidence of a perfected security interest in the property. All right. Statutes of limitations. So every state has limitations. All right, where the bank after a certain amount of time cannot foreclose. Each state has strict statutes of limitations on when a bank can initiate foreclosure proceedings. These times vary by state, but generally range from 3 to 6 years after the homeowner default or on the last payment made on a loan. If the statute of limitation has expired, the bank can no longer have the legal right to foreclose, and homeowners can use this as a defense. All right. So check the states. Most states are 3 to 6 years. All right. If they have expired, then that foreclosure, they have no right to foreclose. Lack of consideration. For a contract to be legally valid, there must be adequate consideration or value exchange between the parties. In the case of a mortgage contract, the bank must demonstrate that it provided value, typically in the form of a loan in exchange for the promissory note. If the bank cannot provide evidence that it provided value for the promissory note, the contract may be deemed unenforceable due to the lack of consideration. All right. A legally valid contract requires adequate consideration or value exchange between the parties. The bank's burden. The bank must demonstrate that it provided value, typically a loan in exchange for the promissory note. If the bank cannot provide evidence of consideration, the mortgage contract may be unenforceable. All right. Predatory lending practice such as excessive fees, deceptive terms, target vulnerable borrowers can render a mortgage contract unconscionable and unenforceable. If a homeowner can demonstrate that the bank engaged in these actions, it may provide a defense. Excessive fees, things like that. We know that all that stuff goes on in a lot of these loans, from houses to mortgages. I mean, from auto loans, things like that. So we have to understand the fees in these loans, and that's stuff that we will learn. So here's some other things. Equitable estoppel. The doctrine of equitable estoppel may prevent the bank from foreclosing if the actions have led to the homeowner to reasonably believe that the bank will not pursue foreclosure. So if they say they won't pursue foreclosure and they go ahead and do it, and they told you they wouldn't, and you have made partial payments or you got written assurances, those are things that the bank you can use against them. All right, because these are things that they do. They lie. They tell you certain things, or they tell you half truths. These are all things that happen in certain situations with dealing with some of these banks. The bank's action or assurance must have led to the homeowner to reasonably believe foreclosure would not occur. So that's one key thing. The homeowner must have relied on the bank's conduct in a way that will make foreclosure inequitable. The doctrine of equitable estoppel may prevent the bank from foreclosing due to its own actions. So you have unclean act. The unclean doctrine is an equitable principle that may bar the bank from seeking equitable release, such as foreclosure. Now, this is an equitable thing that's supposed to be done in equity, what they call equity court, but we have to go into a statutory court to be able to get to the equity court. If the bank has engaged in a fraudulent or inequitable conduct, if the homeowner can demonstrate that the bank has acted in bad faith with fraudulent or deceptive practices, the court may invoke the unclean hand doctrine and deny the bank's request for foreclosure. 1. Bank misconduct. The bank has engaged in fraudulent, deceptive, or inequitable conduct. Equitable release. The bank is seeking equitable remedies such as foreclosure. Unclean hands. The court may invoke the unclean hands doctrine and deny the bank request due to its own misconduct. Breach of duty of good faith and fair dealing. Mortgage contracts contain an implied duty of good faith and fair dealing, which requires the parties to act in a reasonable, fair manner towards each other. If the homeowner can demonstrate that the bank has breached this duty through its actions, it may provide a defense against foreclosure or grounds for damages. Examples of potential breaches include failing to properly serve the loan, engaging in deceptive practices of unreasonable denying loan modifications or relief. Okay, so potential breaches, we just went over a few: failure to properly credit payments, provide accurate statement, respond to inquiry, misrepresent terms, fees, the homeowner's rights and obligations, refusing to consider loan modification or other relief without justification. Now, again, these are all some things. I'm sure there's more. We have access to get the information. The key is how you work this thing in court, how you file paperwork, how you do certain things. That is what I want to give you: keys to education, and then the understanding, the wisdom behind it, the application. I want you to apply it. And these are the things that I can show you. If you go to the link in the bio, ASKLEGALSHERPA.com, go to the link in the bio, get a consultation, and then I will give you access to what is needed, or I will just answer your questions that you have, so you don't have to spend thousands and thousands of dollars. Again, this is all educational. This is all education. It's all on the internet. It's on different places. It's in the books. But again, this is put in a way that it's going to be tailored to you in your county, in your area, in the state that you live in. It's going to help you. So I look forward to talking to you and working with you. This is Lex. Y'all have a wonderful and awesome day, and I'll talk to you soon.